Hi there, folks. Charlie Gipple, certified financial planner here. Hey, I want to talk a little bit about probate, the process that your estate goes through many times after you pass away. And secondly, want to talk about the three most important estate planning documents. Estate planning documents, the three most important. Now, when a lot of people think of estate planning, they tune the person out, right? Well, I don't have an estate tax issue. I don't have assets over $13.6 million, which is what you need this year for estate taxes to kick in, which, by the way, is dropping by half in 2026 for those of you with a lot of money. But a lot of folks tend to poo-poo, so to speak, the estate planning notion because, oh, it only applies to the rich. It does not. Estate planning is also avoiding probate. Who gets your assets after you pass away? If you become incapacitated and can no longer make decisions for yourself, who controls the estate? From a financial standpoint, as well as who controls the healthcare decisions if you become incapacitated around your own healthcare. Let's talk a little bit about that. First of all, the process of probate. Then we'll talk about the three documents that most of you should consider. The process of probate is this. It's a horrible process. When you pass away, who determines where your assets go? Well, if you don't have a trust, if you don't have a will, that means you die intestate without a will. And that's up to the laws of the state. Who gets your property? Heck, who takes care of your kids as guardians, right? But many times when somebody passes away, they have a will. Do wills go through probate, or do wills avoid the probate process? They do not avoid the probate process. The probate process is where judges and attorneys determine where your assets go. And the will is a roadmap through that many times 9 months, a year process that is called probate, right? So if you have a will, which can't just be something written on a piece of paper, you have to, in the state of Iowa, you have to have 2 witnesses. Wills certainly help, but they don't avoid probate. Probate is this: the executor of your estate, who you name in your will, they have to open up a probate estate. Then they have to file in the local newspaper a notice of petition of probate that goes out that says, creditors, people that Charlie Gipple owes money to, he died. Come and get your money. Come and talk to the estate, the executor, to get your money. That's about a 4-month process that process needs to be opened up. You know, the articles in the newspaper. So now we're, 4, 5, 6 months in or so. And then, of course, the record keeping. You have to go through the person that passed away, all their records. Who do they owe money to? What are their assets? Where are their assets? Et cetera, et cetera. It can very easily be a year or 2 in some cases when it comes to the process of probate. And by the way, the process of probate is expensive. Those judges, those attorneys, they cost something. Here in Iowa, anywhere from 2% to 5% of the value of the estate. So you have somebody worth $1 million. They pass away. We're talking $20,000 to $50,000 of their estate gone through to the probate process, right? So that's where there's a cheaper way to do it, and certainly a more efficient way to do it, to avoid that expenditure, to avoid the hassle of your loved ones that they would otherwise have to go through. That is 3 different documents. Actually, the first 2 are the ones that pertain to avoiding probate. So let's talk about them. First one is a revocable trust. By the way, if you pass away with assets of like less than $100,000 in the state of Iowa, you probably don't need a revocable trust, right? Because there's an expedited probate process. But for many of you, a revocable trust, document number 1 of 3, is very important. What a revocable trust is when you start naming the assets with the owner as the trust, what happens? First of all, you lose no control. That's what a revocable trust is versus an irrevocable trust where you do lose control. You don't lose any control of those assets. You still effectively own those assets. But once you pass away, think of it as a beneficiary designation, right? The beneficiary of that trust, the assets, they get distributed to the beneficiaries, period. No judges, no attorneys. Those assets that are now named in the trust, or that the trust is named as the owner or beneficiary, those assets are no longer subject to this root canal of a process called probate, right? So these assets avoid probate. Okay, well, what about the second document? This is a pour-over will. I use this analogy a lot. Let's say you pass away, and on the day that you pass away, you have a lottery ticket worth $100 million in your pocket. That lottery ticket wasn't owned by a trust, obviously. It doesn't have a beneficiary designation on it. So where does that $100 million go? The judges and attorneys determine where that goes, right? Now, that's a little bit of an exaggeration, that example, but all the time there are assets being excluded from the trust that somebody set up, right? Oops, I forgot to put this property in this trust right here. So what happens to that property? This is where the pour over will comes into play that says, hey, in case we forgot to include certain property in this trust or to title the trust as the owner of certain property, how should that property be distributed to the beneficiaries? Well, it references the revocable trust and says, like how we did it over there, that's how the assets that we forgot from the trust, that's how those assets should be distributed. And that is what a pour over will is. Yes, that property still goes through probate, but at least you have that roadmap for the judges and attorneys to properly determine where those assets go. That's document number 2. Document number 3 has to do with financial power of attorney, as well as healthcare power of attorneys. Healthcare financial power of attorney, as in, if I get dementia, for instance, if I can't think for myself, who will help me make who will make the very important financial decisions? That's a financial power of attorney, as well as a healthcare power of attorney. If I can't think straight, who's going to determine how I am taken care of from a healthcare standpoint? Well, I would have somebody that I trust as the healthcare power of attorney. So folks, those are the 3 documents: revocable trust, pour over will, power of attorneys. You may want to throw medical directives in there as well, which is a topic for another day. Feel free to call me if you have questions. I also have partnerships with attorneys that actually draft these trusts, these power of attorneys. Some of the best in the state of Iowa, by the way, folks. But call me if you have any questions. My number is 515-986-3065. You can also visit my website that's right there in front of you. Hope you enjoyed the video.